Okay, so we've still got people joining, but I think we'll make a start because we've got quite a lot of information to get through today. We've got around about 3/4 of an hour we're scheduled for this, but we've got quite a few slides and quite a lot of information. So probably best that we make a start quick, I suppose. So David, if you can push on the screen one slide, please. Okay, so just a quick intro then initially. So my name's Irving Hill. Hello, I'm the Chief Exec of Sulets. So just a little bit about who we are. Sulets is an ethically led student lettings charity based in Leicester, and we operate around about 2,300 bed spaces through a mixture of halls and houses in the city. We are linked to the 2 universities and the 2 student unions, and as I say, it's an educational charity that's been running for around about 10 years. Once again, we're joined today by industry expert David Smith from JMW Solicitors. Just as a quick intro to him, David's the lead legal advisor for the National Residential Landlords Association and has extensive knowledge and has played an extensive role during the representations to DLUHC on this bill. So whilst the bill is obviously a major new piece of legislation, and it's probably the biggest change in landlord and letting law in 35 years, we are going to be specifically focusing again on the student sector because that's the area obviously that I'm interested in, and that's the area that it's a very niche field, but it's pretty substantial. So yes, I will push on now. The one thing I will ask is, if people can submit questions along the way, we will try and answer as many of them as we can. We have had people that have submitted some in advance, so I've tried to time those into the slides along the way. So we've got some already submitted questions that we're going to post to David. But as I say, as we're running through the slides, feel free to put questions down on the Q&A, and we will answer as many of them as we possibly can. So with that, I will say hello to David, and yeah, maybe if we can press on and make a start with the first of the slides there, David.
Great. Hi, everyone. So I've previously talked, of course, about the Renters Reform Bill. And what we talked about it before was after its second reading. It's then been through a committee stage in the House of Commons where the government saw fit to put down 111 pages of amendments to the bill, which is quite a lot. Just in case anyone's in doubt, it's not normal for 111 pages of amendments to appear by the government to its own bill. So what I want to talk about is some of the things that have changed really about the bill during the course of those amendments. I'm not going to harp too much on things that have already happened. You can watch previous webinars to see what the sort of overall scope is. I'm going to focus more on things that have changed. So obviously things that were in the bill originally, getting rid of Section 21 notices, open-ended tenancies from the start, so no fixed terms effectively, new grounds for possession, rent only being monthly, some degree of control around the way rent increases operate, were all sort of the key things. There were additional things about permission for pets, written tenancy terms, the way tenants give notice being longer, lots more civil penalties, a compulsion on landlords to join redress schemes, the property portal, effectively a national landlord register, and some changes to enforcement authorities. Things that were not in the Renters Reform Bill originally was a short let portal. That has now actually been passed into law through the Levelling Up and Regeneration Act. So there's a whole scheme for landlords who are doing short letting to sign up to, or there will be shortly. The decent home standard, and bans on saying no kids or no DSS. So those were things that hadn't appeared. So let's jump on and let's see where we are today. So the bill, of course, has, as I already indicated, changed a fair bit. So there were things added in at committee stage which we expected. So I think unsurprisingly, the government has added in a requirement to meet the decent homes standard. I'm not going to say much more about that today because that's literally all they have done. They've put in a section saying, we will introduce a decent home standard and you have to meet it. But until they introduce it, that probably won't be for months and months and months. Nobody knows what the detail is. It will be done by regulations later. They've introduced a ban on marketing properties as not suitable for children or not suitable for people on benefits. I'm not going to say a huge amount about it today because it's not really very connected with our topic area. Other things that we were less expecting is a new ground for possession for student tenants. So I'm going to talk about that, unsurprisingly, a fair bit as we get through today. Rather more powers for local authorities to investigate offences, a whole new suite of further civil penalties, and also changing a Supreme Court case called Rackerson and Jepson, which related to unlawful subletting, which I'm going to mention because it does happen a fair bit in the student market. Going forward, I'm going to talk about a bit where we're going forward and the next phases, because there's a hell of a lot of further amendments being tabled to this bill, a lot of them by Conservative MPs, which are quite powerful. And then we are still waiting for the next stage in the Commons, which is the third reading, which would mark the end of this bill's transit through the House of Commons and its movement to the House of Lords. Yet again, and this keeps happening, the government is stalling somewhat on the third reading and the report stage of this bill. And that's for reasons I will get back to in just a moment.
Okay, so before we go on any further, to the next slide, a couple of questions that I've got here that have been posed. So you won't be too surprised to learn that one of the biggest areas of people attending today are asking about what's the likely time frame. This is a little difficult for anybody to answer, but what is the likely time frame for this to become law, if it does? Another interesting question was, what changes can we expect from a Labour government? So to that end, it was if the bill does not complete its path through Parliament. So by that, what I mean is, let's assume that the bill just dies. So what happens? And I think the simple answer is it will die there. And then what happens if the bill does pass, but it's left to, say, an incoming government, and let's assume it's Labour, it's left to an incoming government to bring in regulations. So what's the likely time frame for this, given what's happening with the Conservative government at the moment? B, what happens if the bill actually, if it doesn't complete and they go for a general election? And C, if it does complete, what about the situation with regard to regulations?
Right. Excuse me while I just pop up my crystal ball for you. I'm going to talk a bit more about this later, but right. I mean, everything obviously comes down to the election, and because nobody knows when the election is going to be, it's hard to say. There seems to be a bit of a push to get this done, but then again, the government's introduced lots of new legislation, some of it just last night, and has made commitments to new legislation that's got to push through. So there's a timing issue. Most people I'm talking to are saying that the election is likely to be called in October for November, but you can never be sure. Obviously, if an election is called for May, this bill isn't going to get done before May.
Right.
If it's called for October to be in November, then yeah, it might. But that would still leave an implementation timeline, and that would probably be done by whoever the next government is. And the reality then is that is likely to be a Labour government. Now, this is a bit of a catch-22. There are quite a lot of people who'd like to see this bill just go away, and I get that. But the problem is that the Labour government has already said that they will get rid of Section 21 inside the first 100 days. Angela Rayner made that commitment, and I think they'll stick to it. If they have to. So if the Renters Reform Bill has been passed, then all they will do is implement it, and their sort of ability to do that will be quite limited because they can only operate within the scope of the regulations that exist. That does give some degree of latitude, but only a certain amount. And I don't think there'll be a huge amount of playing with the bill. I think the Labour Party will just bring it in. If this bill hasn't passed, then it's back to the drawing board, and the Labour Party will start a new bill. I'm sure it'll look similar in many ways, but I think it'll go a lot further and it'll do a lot more, and probably more than most people would like to see.
So potentially, given that we've got, as we were discussing only the other day, potentially given that we've got sort of a precedent with regard to what happened in Wales, because obviously they've introduced something that's significantly tighter than this, haven't they? So if people think that it's going to go away, it'll potentially under
It won't go away.
be tough
If it goes away, it'll go away to come back. And I would imagine, yeah, Labour solution is I mean, the most obvious model is what the Labour government did in Wales, and I could see that being placed in England, yeah, for sure. So something quite extreme and quite radical.
Right. Okay. So Section 21 and open-ended tenancies then.
So yeah, as already said, Section 21 is being disposed of as part of the Renters Reform Bill. It just won't exist. There will not be assured short-hold tenancies. And in fact, all tenancies are open-ended. You can't have a fixed-term tenancy, and trying to offer a fixed-term tenancy is actually an offence, and you could be civil penaltied for doing it as well by a local authority. So in effect, all tenants have open-ended tenancies in theory for life, rather like fully assured tenancies, and then an expanded collection of grounds of possession linked to specific events. Tenants are in a very happy position under this system of being able to give notice within 2 months. So the difficulty for landlords is the tenants could walk in, give 2 months notice, and walk out again 2 months later. But equally, the tenant could walk in and just stay there for the next 20 years. And in principle, the landlord can't do anything about that if the tenant does what they're supposed to do. Now, there is an amendment that has been put forward, and I think is now, if this bill goes ahead, is more likely to be accepted than not, which creates a sort of quasi fixed term equivalent in the sense that it will prevent tenants giving 2 months notice inside the first 4 months of the tenancy. So in effect, tenants will be there for 6 months minimum, which I think is helpful to some landlords in the sense that they'll be able to defray their costs of getting the tenant in there and all this stuff. So there's a sort of change there, which is interesting, but probably not terribly interesting to the student market, because not that many. Well, it will help in some cases. Some students do arrive at university, decide they don't like it, and try and walk out the door again. And in principle, under the Renters Reform Bill, they would be able to do that and leave landlords with vacant properties, fairly early in the student year, with limited prospects of filling them. It's going to be a lot harder for students to do that. They're going to have to sit it out.
Yeah, sure. Okay, I've got a couple of questions here. Rex,
I just knew you would.
Yeah, I'm just waiting for you, David. I'm waiting for you. Rex has asked if there was an exception for the Section 21 notice for students. What would happen if we have a house of 5 and 3 are lecture students and the other 2 are working?
But there are no Section 21 notice exceptions for students. It just doesn't work that way. Nobody gets Section 21 notice.
I suppose what he's talking about is potentially what we were just saying there, the idea that there'll be, well, some sort of exemption for a certain amount of months. Or so. Maybe this is more along the lines of that you've got a joint tenancy, one person wants to leave, and what happens to the remainder? Maybe that's the...
I'll come back to that in a moment.
Okay, sure. And in fact, we've got another one from Ian that says the same sort of thing: mixed occupancy, 2 professional support, 5 students. Okay, let's press on.
Let's push on, and I think I'm going to answer these.
We will answer that.
Yeah. So obviously, the loss of the fixed terms is potentially difficult for the student sector market. There is an exemption for purpose-built student accommodation. Now, this is a bit complicated because this exemption kind of exists already. So what you have to bear in mind is when people talk about the Renters Reform Bill is much of the Renters Reform Bill actually modifies the Housing Act 1988. So the Housing Act 1988 will continue to exist just in a highly modified form. So the Housing Act 1988 has an exemption in it for specified educational institutions who are set out in regulations. And those regulations change from time to time to name educational institutions or other similar entities. Broadly, who have signed up to the Unipol or ANUK code for letting their properties. The plan, apparently, is that structural exemption will still exist, but it will be rewritten to expand it. And instead of simply talking about named entities, it will do it on a class basis. and say that purpose-built student accommodation, where people have signed up to probably Unipol, but probably ANUK codes of practice, will be exempted. Now, what that means is that those people won't be renting within the Housing Act 88 at all, so they will be able to offer fixed-term tenancies. They won't be using Section 21 notices. They will be common law tenancies that will just end by default at the end of the fixed term. So it's not a case that there'll be a Section 21 exemption. Section 21 still won't exist. There will be a class of student landlords who will be renting outside the scope altogether of the Housing Act 1988. Now, this is kind of a bad thing in many ways, because that actually means that lots of protections that you would normally expect tenants to have, like, for example, tenancy deposit protection, just won't exist for lots of those people. So it's a bit of a concern. But it's also a little bit of a nonsense, because quite a lot of purpose-built student accommodation doesn't use tenancies. An awful lot of purpose-built student accommodation actually provides in-room services such as cleaning, and therefore they are effectively like posh hotel accommodation and are let on licenses, because the tenants, the occupiers, don't have exclusive possession of the property. So in fact, it's a bit of an exemption that for many PBSA providers probably won't be that interesting, because they're not within the scope of the legislation anyway and never were. So there's kind of a bit of a nonsense about the whole thing.
Do you see any potential for this to be expanded to, say, the PRS? I mean,
that's not currently what's being said. There have been a number of suggestions that might happen, but at the moment I see it more as wishful thinking.
Really?
For reasons I'm about to get onto, which we talk to the next slide, because the government has produced what it considers to be a solution to the problem. So what the government has done in the committee stage is created a new ground for possession, which is ground 4 big A. That may not be its final numbering. Numbering of grounds may change as the bill progresses, but at the moment it's being called ground 4A. And what this basically is a ground for possession that landlords in the student sector can use with a Section 8 notice. So we don't bring back Section 21 notices. We're not creating a Section 21 notice exemption. What we're creating is a ground possession you can use with a Section 8 notice. Admittedly, it looks a lot like a Section 21 notice, operates in similar ways, but it isn't a Section 21 notice, it is a Section 8 notice. I appreciate I'm being pedantic, but I am a lawyer. What do you expect? So ground 4A is a 2-month notice period, rather like a Section 21, I accept. But it is only available if all of the occupiers of the property are full-time students at the start of the tenancy, or at the start of the tenancy, the landlord believed they would become full-time students. So the answer to people who are saying, what happens if I have a mixed property, is you won't be using ground 4A.
Right.
Is the short answer to that question.
So Rex and Ian, that's hopefully answered your questions then.
Yeah. The notice must also expire between the 1st of June and the 30th of September as well. So it's time-locked to a window of time, which is when we normally expect most students, although in my view, by no means all students, and there are clear issues here in relation to postgraduate courses, various types of access courses, and other specialty courses. But the notice must expire between the 1st of June and 30th of September. Another requirement is that the dwelling house must be an HMO, which means that, of course, if you have a 1-bed property that's let to a student that's not an HMO, or a 2-bed flat that's let to a student that's not let to a pair of sharing students, that won't be an HMO. That knocks those out of this position, and potentially will largely mean that PRS landlords will consider not letting to students at all, so removing them from the sector. That is quite a concern, because there are parts of the country where 2-bed flats shared by students, for example, are quite a common feature of the student sector. None of those properties will work with ground 4A. There is also a problem that the wording is terrible, and it's not clear whether the government really intends by roomlets and HMOs. So what they've said in the ground is that the tenants must be joint tenants and the dwelling house must be an HMO. But in the Housing Act 88, a dwelling house is not used to refer to a whole property. It's normally used to refer to, it's often used to refer to a room. So if I have a room let, the reason a room let is an assured short hold tenancy is because we recategorize just the room as the dwelling house. And the government hasn't really got its head around this when it wrote the legislation. So the way it's ended up writing it is it's arguable that if you break the property up into room lets, you can't rely on ground 4A because each dwelling house won't be an HMO, although the whole building will be an HMO. It's a bit of a mess. And obviously, if it's all done on room lets and it's to individuals, there won't be a joint tenancy because there'll just be one of them. So it's a bit unclear, one, what the government is actually trying to do with this. And without understanding their thinking, it's a bit hard to, and one of the problems with these things is that thinking's never very clearly set out in committee stages. It's a bit hard to understand exactly what it is that the government's trying to do with ground 4A. But as it stands, it's a bit of a pig's ear. And of course, at some level, it's not really a fix. And this is one of these sort of weird catch-22s that is we all know is true, but it's not something you can reasonably say, because the reality is that fixed-term tenancies are quite powerful. People tend to leave at the end of a fixed term because it's a fixed term. Most landlords don't serve notice or don't need to serve notice for tenants to leave. That will not be the case here. Student tenants will have open-ended tenancies, and landlords will have to serve 2 months' notice. And that notice will come with all kinds of caveats about contesting it and all the rest of it. And you just tend to find that when you're in that situation, people are less likely to comply with the notice and are more likely to be flexible with it. So in a sense, the government's position is this is as good as the old system, because even with a fixed term tenancy, technically students could stay and you had to serve them Section 21 anyway. And lo and behold, we've given you exactly a new system where students can stay and you have to serve them a ground 4A notice anyway.
Yeah.
But in practice, we all know that those aren't really the same things. It's a very difficult argument to make to government without looking a bit evil.
No, well, I mean, if you look at a piece of paper and it says you stay from date X to date Y, that's a very powerful thing. As you say, you've always been able to stay beyond that and turn it into a periodic tenancy, but you know, having it written down that you leave on the 30th of June is quite a powerful thing, as opposed to just having an open-ended one. You've now got to go and issue this document, haven't you? So yeah. I mean, one question I was asked, was, I mean, which is fairly easy to answer, I think, is do you think this will be challenged or amended as it progresses through the House of Lords? And potentially, yes, it could be, couldn't it?
Yeah, I mean, I don't doubt that further amendments will be tabled in the House of Lords, but there'll be more technical, and they're the kind of thing that might change this. There is actually an amendment already being tabled to ground 4A to basically scrub out the HMO requirement, which would solve most of the problems I'm talking about.
So that would solve the 1 and 2 bed scenario, or the 2 bed flat, or anything like that.
Well, in practice, it would probably solve the rest of the problems as well.
Right. Okay.
But it's not ideal by any, and of course, no one can guarantee that amendments will be accepted. But they are the current amendments are getting quite a lot of traction. Right. So tenants, of course, can also give notice. And one of the interesting points about this is tenants can give notice for 2 months or such shorter time as you've agreed in writing. You can't dictate the means of notice. So basically, tenants can give notice by email, but you can dictate place of notice. So you can say, well, you can give notice by email to this email address. There is some real confusion about this among the tenant sector, because a lot of tenant groups are saying, oh, that means that landlords can't force tenants to give notice to their agent and things like that. And that absolutely is not true. The law distinguishes quite heavily between means of notice and place of notice, and they don't mean the same thing at all. And the legislation is talking about means, not place. Now, I suspect most landlords in the PRS will enforce this strictly, and I think it's a bit unfair on students, because in practice, what this means is that students will tend to come into university in PBSA accommodation, because more first years live in purpose-built accommodation, whether provided by their university or by a third party. And in those situations, they'll be on a fixed-term tenancy and won't have to give notice. They'll just be expected to leave at the end of term, and will no doubt leave before the end of the term anyway. But If you go into your second year into private accommodation, students will be expected to give 2 months' notice. And I would anticipate landlords saying, well, you have to give me notice. And if you don't give me notice, I will charge you for the 2 months. And so students will be being asked to give 2 months' notice, often when they're in the middle of their summer exams or in their end of term exams, and may have other things on their mind. And it's a bit of a mess. The other problem is joint tenants. Inside a fixed term tenancy, if there's a break clause, all joint tenants must give notice together. If your tenancies are periodic, and all tenancies will be periodic from the get-go under this new regime, then any one tenant on their own can give notice, and that will terminate the tenancy for everybody. So the problem with all of this is, what happens if you have a group of 4 or 5 tenants who are sharing, and one of them basically falls out with all of the others and wants to leave? Under the current system, what you'll say to them is, well, you're inside a fixed term, you can't just walk away. You need to find someone else. You'll probably get lots of emails from the parents about how mean everyone else is to them, to their son/daughter, and how mean you're being. But you'll probably hold firm. They'll eventually find somebody else to take their place, or they'll pay the difference. And from the landlord's perspective, things won't change very much. Under the new regime, the tenant will be able to turn around and give you 2 months' notice, terminating the tenancy for everybody. And it will then be up to the landlord to either recontract with a smaller group of people and try to get the same money out of them with an empty room, seems unlikely, or to assist them in finding another person within 2 months to refill that room and relet to them. So it's more complicated. And of course, bearing in mind all of this will require reprotection of tenancy deposits and all of that stuff as well.
I mean, presumably, could that also mean the landlord could say, oh, okay, actually, I'll accept that, the first tenant wants to leave and you're all off then? Presumably
Absolutely.
That's an outcome as well.
The landlord could simply say, a plague on all your houses, you can all just get out. But of course, then that leaves a group of students unaccommodated, which is a pretty dissatisfactory position, but that's not the landlord's problem. But also it means, of course, that a landlord will potentially have a vacant property partway through a term.
Yeah, which is not a desirable outcome for them, obviously.
No, and it can be, and in some areas it won't be a problem because you'll fill it. But in other areas, it will be a quite distinct problem where student letting is really the letting market, and and properties that you're letting outside the student sector are often to less desirable tenants or at lower value, or just remain unlet. So it does very much depend on where you are in the world and what your student market is like and how predominant it is. So to give a classic example, in Oxford, for example, the student market is important, but it's not the entire letting market. In Cambridge, the student market is quite a large part of the letting market. And students leaving partway through a term in Oxford, you'll replace them probably with non-students. In Cambridge, you may not have so many options. It becomes more difficult.
Right.
And obviously, people are free to say in the chat that I know nothing about the letting market in Oxford and Cambridge, and you'd be right about that. I know very little about it, but there we go. It's an example. Sorry, don't move on just yet. Go back. Sorry, David. Just hold on. Obviously, one solution of this for some of this problem will be for landlords to do room lets, because then if one tenant leaves, it has nothing to do with all the other tenants. But obviously, that really depends on how Ground 4A works. I've just cheerfully said that Ground 4A may not work very well for room lets. So there's a sort of like, well, hang on a minute. If we move to room lets, are we going to forfeit Ground 4A? And that there is a problem there. But moving to room lets potentially solves the issue of, if you can make Ground 4A work and the government sorts it out, it also potentially solves the problem of mixed property, because each room let would be considered either let to a student or not let to a student. You could rely on Ground 4A for the student ones and not for the other ones. And it sort of solves this mixed issue. But the government needs to fix Ground 4A and make it work better in practice. The other thing we need to think about with early termination and 2 months' notice is summer vacancy, because the reality is students have never wanted 12-month tenancies. What students actually want is around 8 to 9 months, from broadly September till about July-ish or thereabouts, depending on the institution. There obviously are postgrad students who want to stay, and there are exceptions to that. But most students, want to leave and have the summer vacant. Landlords have generally tried to keep them in place because otherwise they have to pay council tax for vacant properties. And there are different ways of doing this. You either sign on fixed-term tenancies that run through the summer and just hold them to it, or you start their tenancy early, and you're running through the summer period, usually with some kind of weird and wonderful deal about reduced rent, allowing the landlord to enter into the property and do works, or some kind of deal like that. But people are going to have to think about the structure, and I tend to find that different, or in my experience, different student markets in different parts of the country tend to operate in their own little way that's specific, and there's no hard and fast rules that apply across the whole student sector for this. But I suspect most people are going to have to deal with it by starting tenancies earlier and having a reduced rent for the summer, and making students sign up. But the problem with all of that, and I'm going to get to this in a minute, is, of course, if you can't be 100% certain your previous tenants are going to leave without going to court, then signing up your next group of tenants early is a high-risk strategy.
Yeah.
And,
is there any good news?
Always in this very, and the government just doesn't really appreciate the risk. They say, well, the risk always existed, but the risk just was much lower. It's going to be much higher under a new system. Moving on. So options, you could try letting to an approved PBSA provider to sublet. I can't guarantee that will work because the Unipol and ANUK codes don't normally allow people to sign up to them where they're letting houses. So there's a problem that letting and subletting may not comply, or it doesn't comply with the current versions of the Unipol and ANUK codes. And so if the government is going to say that a PBSA provider can only do this if they're on the Unipol code, then there's a risk that they won't accept. They won't be within the scope of the Unipol code. You can, I guess, accept the new system and try and find a way to work within it. I expect many landlords will in practice, at least for a time. You could try shifting to using licenses instead of tenancies, or you could shift to premium leases instead of tenancies, both of which I'm going to discuss in a minute. You can use subject to contract more aggressively. So you can simply, a lot of landlords will sign students up and execute the tenancies several months before the tenants move in. You could simply get the students to sign their tenancy, not sign it yourself and say it's subject to contract, and just leave it flexible up until the point that you know that the previous occupants are going to leave, and then sign the tenancy and execute it. The danger, of course, with doing that is if you can walk out, so can the tenants, the students, so they could walk away on you as well and basically either all fall out over the summer and go somewhere else, or better deal you for another property. So there's always a risk with relying on flexibility. You can think about room letting in various contexts, those subject to ground 4A, or alternatively, I guess you could quit the student market and move into some other context. And while I've said that jokingly, I don't doubt for a moment that in some areas, there will be student landlords who will be looking very closely at Airbnb, holiday letting, or some other mechanism of letting.
Yeah, I mean, this has certainly happened in Scotland, doesn't it, where they've done similar stuff, and the market is sort of contracted quite significantly, isn't it?
Yeah, and it does rely on local environment. I mean, the evidence from Edinburgh is particularly stark. So Edinburgh, a lot of student landlords simply moved to the holiday let market, which was a bit more hassle for them, but actually had similar returns or higher returns, had better tax deductibility. And obviously Edinburgh has no shortage of holiday letting, but obviously what works in Edinburgh is not necessarily going to work in every other student market. Much as I'm sure everyone has the best student properties, there are student areas of the country that are less valuable to tourists as a tourism hotspot. So, with the best will in the world, Southampton, lovely as it is not a major tourist hotspot in the UK. Obviously, if you're in Oxford or London, that is not the same discussion. Those are both strong tourist areas, and a degree of flexibility is undoubtedly possible.
Yeah.
But not everywhere is the same. And I'm not going to insult casually naming popular student towns and calling into question their tourism desirability. And I'm sure someone will immediately on the chat say Southampton's mega popular with tourists. What are you talking about?
Absolutely.
Yes, I know it's not.
It's a matter of time before that's flooded. I'll cut in with a quick question, but I think you've answered it at the start, really. Richard said, at the last webinar, we were told unis will be exempt from Renters Reform Bill. So when RRB becomes effective, do you think unis will offer private sector landlords of student lets the opportunity to lease their houses from them as a way of way of the PRS avoiding the RRB? Yeah.
They might, but it depends on the way in which the government cuts up the regulations. At the moment, they've indicated that people will have to sign up to the Unipol or ANUK code, and both of those codes were altered at the behest of the government, actually. Although a previous Conservative government, obviously when I say the government at the moment, it tends to embrace a pretty wide range of parties, but under the May government, the Unipol and ANUK codes were altered at the behest of the Housing Minister to exclude situations where universities were taking on properties and then reletting them as reletting houses. So you can't, that they don't sit within the Unipol code at the moment. That could change.
Okay.
Moving on. So I mentioned licenses and room lets. Licenses fall outside the Housing Act 1988 because the Housing Act 1988 only applies to tenancies. So they are not affected by the Renters Reform Bill, but they are more difficult to do. If you want to offer a license rather than a tenancy, you need to offer in-room services that require you to routinely enter into somebody's room to provide them. And the most obvious example is cleaning. And the model I always point out to people is hotels. Hotels aren't hotels because there's some magic act called the Hotels Act that says hotels aren't tenancies. Hotels are hotels because you don't live there. You go there for short-term accommodation, and because they offer in-room cleaning. That is why it is really difficult to keep room service out of your room for more than about 24 hours in a hotel. They want to come in. They need to come in. They're trained to do so. But a lot of judges and courts view this with some suspicion, so you'll need to prove you're doing it. And local authorities are a bit confused about it and see it as a sham and often turn around and try and penalty people who are doing it or suggest that they're acting illegally, even though they are not. So it is possible to move to licenses, but you'll have to do it in a fairly structured way, and it's quite complicated, and it's not something, and I've said this a couple of times to people, and people have rushed up to me afterwards and said, oh, how do I move to a license arrangement? It's not really something one deals with in a couple of minutes. It's quite a subtle and complex beast.
Yeah.
And no doubt someone is busy typing into the Q&A right now, how much cleaning do I have to do? If I clean it once a term, is that enough? And the answer is there is no strict answer, but I wouldn't like your chances of getting away with that argument. Obviously, I've talked about room letting a lot. I think it's potentially a rational response to tenants giving notice and giving landlords more control over occupiers, but Ground 4A and the way it's being created is problematic. And every time I read it, I have a different interpretation of it. So it's very difficult to decide how it's going to work out. And ultimately, if the government doesn't fix it, it's going to be hashed out in courts at senior level, and that's not really ideal. I mean, it's ideal for lawyers, obviously. It's not ideal from the landlord sector to have these things being left in an uncertain position in courts for a period of time.
Okay. So just to reiterate on the licenses, this is something that people need specific legal advice on if they wanted to try to avail themselves.
It's doable, but I would say to you, if you've got one house, I probably wouldn't be going down this road. If you've got a significant-ish portfolio, or you're an agent for a significant-ish portfolio, it may work, but you'd have to think about it.
Yeah. It's probably worthwhile cutting in. There's a question. There's one of the Q&As. Robin Walsh has said, a point of clarity, the two codes are the UUK code, the Accommodation Code of Practice, which is the one that applies to the university.
Sorry, I said ANUK when I should have said UUK, shouldn't I?
Yeah, and the ANUK Unipol code, the national code. The former is the university PBSA. The latter is the private PBSA. Yeah. So sorry. Yeah, the universities are all in the UUK code, and everybody else,
is Unipol.
Is under the Unipol.
Sorry, I always get mixed up. There's too many things that have U's in there for my little brain.
Yeah, thank you for that, Robin. That's good point. Right. Okay. So should we move on?
Yeah. So premium leases. Now, these were historic things that were very common in London for a long time for tax reasons, up until the point that Gordon Brown, and obviously I'm showing my age here, Gordon Brown changed tax laws to make them less attractive, and they disappeared. But in fact, people deal with premium leases all the time. If you buy a flat, that is a form of premium lease. What you are doing is you are paying a premium, i.e. the purchase price, in order for someone to grant you the lease of your flat for 125 years, and then you pay a ground rent, which is usually set at a pretty low level. But you can do exactly the same thing in a short-term tenancy. So essentially, you charge a premium, which just happens to be 12 months rent, just happens to be the same number, for the granting of a 12-month lease, and then you charge a ground rent of £1 a month or something equally low. And this works because the Housing Act 88 has minimum rent thresholds in it of a few £100s a year, and you go in below them, and it falls outside the scope of the Housing Act 88. People are no doubt going to say, but that's a ridiculous evasion. And I accept that it is a ridiculous evasion, but it's lawful, and it actually did exist for a long time in the UK, in London specifically. So, and it's simply lifting off long lease law. So it will work, it does work, it can be done. It is a short version of a lease for a flat. Obviously, it will garner some degree of suspicion as a deliberate evasion, and people will have to deal with that. But where it will be potentially highly effective is with overseas students who are generally habituated to paying 12 months in advance or similar for their properties anyway. So I've got clients in London particularly who are renting heavily in the overseas market, who are looking closely at premium leases as a solution to this problem.
But again, you would need some pretty significant, you'd need legal advice on this. This isn't the sort of thing that you should do.
It's not a situation where you take an off-the-peg tenancy agreement and do some hacking around with it. It's a specialist document. Again, I wouldn't advise someone who's got one four-bed property to go down this road.
And again, for this to work, they'd realistically have to be paying the rent of the premium, which, as you say, you're going to make this to be 12 months or something like that. They'd have to be in the position that they could pay that in one fell swoop, which is, as you said, that's probably not going to be your typical undergraduate UK student.
No, it really lends itself to people who are letting to overseas students.
Sure.
And that, of course, brings you into a specific scope of universities, although more and more universities are targeting the overseas market. There are some that are stronger in that market than others. There are some student rental sectors that I have more overseas students. It's essentially a way of replicating a PBSA type model without being PBSA.
Sure. Okay. So just keeping an eye on the time, at 11:15. So
sure. I just want to mention a couple of other possession mechanisms. So rent arrears possession, notice periods are now doubled from 4 weeks notice to 2, but the rest is the same. There is a ground for repeated rent arrears, but I don't think it's going to be of terribly great interest. It runs over a 3-year period, so I don't think it's something that's going to interest most student landlords very much.
No.
So I mention it, but we move on. There's a ground for possession to sell, so a new ground 1A, where the tenant has been in place for 6 months and the landlord wishes to sell the property. You have to give 2 months notice, and then you can then sell your property. It is what it is. I presume it's only really of interest to people who are leaving, in which case they're probably not likely to be interested in this webinar, are they? So moving on. Obviously, you need to bear in mind that courts are going to get slower in terms of possession. And if tenants are being given notices saying you've done this wrong or that wrong, or we're asking you to leave for this specific reason, they may be more likely to press back. So, for example, tenants who might just have left, who had actually dropped out of university courses and were no longer students, for example, and therefore where ground 4A won't apply to them, clearly wouldn't have argued about Section 21 or wouldn't have argued on a fixed term tenancy because they had no hope, but might then fancy their chances on pushing back on a ground 4A. So perceived slights or inaccuracies are likely to be more of a problem, and the courts are going to have to actually address all of those, and I don't think the courts will cope with the extra load. At the moment, around 20,000 tenancies are ended through Section 8 notices or equivalent with hearings, but about the same number go through the accelerated possession process, usually on a DIY basis on Section 21, in principle, all of those 20,000 that go through the accelerated process, largely on paper, are now going to have to be done in court before a judge. So I don't know where the extra loading is going to come from to do that. Obviously, it'll be costlier. Fewer landlords will be able to do this themselves, and then we'll have to hire somebody to do it for them. So the expense will go up. Court proceedings will take longer. They'll be more complicated. Arrears are likely to be higher, not least because you simply have to give more notice. So your notice period is 4 weeks instead of 2. So you've got an extra 2 weeks arrears before you even get into a discussion about the courts. And you have to get your notices right, because if you serve your notice wrong and your notice is inaccurate, a local authority is entitled to penalise you for serving an incorrect notice, as some I think will. So there's a whole series of delay factors baked into the system by doing this, and potential for mistake, and therefore risks of more delay in signing up tenants. Sure. Moving on. Rents, as I've said, you can only charge monthly rent. Anything else is of no effect and recalculated as monthly. Now, I'm a bit concerned about this, particularly for overseas students who are often asked to pay rent in advance. The government keeps saying that rent in advance is okay, and there is a provision for return of advance payments in the bill, so it's clearly their intent that rent in advance should be okay. But the wording of the rental reform bill says that rent periods must be 1 month. Now, historically in law, rent periods and payment periods have been different. So if I say to you that your rent is £200 a month, but payable bi-monthly at £400, then the rental period is a month. And so the government presumably is relying on that. But the same piece of text, or the same section of the Act that says that you have to pay rent monthly, also goes on to say that monthly rental periods means where rent is payable monthly. And the government's own definitions, therefore, are getting rid of the classical legal distinction between rent periods and payment periods. So without going into all the technicality, which I've done to a bit, I'm a bit concerned that the way the legislation is written, it doesn't do what the government says it does. So it's a bit of a concern.
Yeah. I mean, even on a simple basis, what it means now is landlords are no longer going to be able to sort of collect typically rent in 3 installments every year or 4 installments every year. So there's added cost there. Plus, you've got the problem of one of the reasons why they generally do that is they time them around student loan period time. So there's better chance of getting the student to pay before they've spent the money or what have you, because they haven't actually generally got a monthly income unless they're working or something like that. So that's going to add to that.
There's more complexity of
costs. Yeah.
So rent increases, I know people have asked about it. I didn't think rent increases were a big thing for student landlords, but people will no doubt be aware of them. The only mechanism to rent increase will be our formal Section 13 notice. And you will have to give 2 months notice, not 1. Basically, what happens is inside that 2-month notice period, the tenant can take it to tribunal and contest a rent increase. If they don't do so within the 2 months, then the rent goes up at the end of the 2-month period. It's that simple. And the tribunal then sets a new rent payable from whatever date. They're supposed to backdate it to the notice date, but in practice, I tend to find they don't. And these tribunal hearings are usually taking 6 to 8 months to be dealt with at the moment, never mind on an increased basis.
I've got one last of the submitted questions that's relevant to this. And Jack said, due to the rent review clauses being abandoned, when will landlords get the opportunity to review and possibly increase rents? And furthermore, how will market rent caps be enforced to prevent landlords charging an excessive amount?
Well, it'll be every 12 months, and the market rent caps are enforced because tenants can take the rent to a tribunal and say that the rent's beyond the market rent.
Right.
I mean, I know there's a lot of concern about landlords using rent to evict people, but the way it's phrased, actually, what the complaint is that landlords will simply increase the rent to a market rent, which will be unaffordable for people. And the answer to that is nothing to do with the private rented sector. It's to do with the quantity of housing, and that's not something you can. I mean, that's rent control by a backdoor mechanism, really.
Yeah. I don't see this being as. I mean, maybe I'm wrong, but I don't see this being as such a major issue anyway, because. For most students, they only want to stay there 1-2 years at the most anyway. If they've been into PBSA in the first year, they're on a 3-year course, but by the end of the second year, they're going anyway, even if they love the place. So I'm not sure that this is going to necessarily be such an issue anyway, because there's a natural churn of students anyway.
Sure, I find that students who stay for a second year and want to stay in the same property will probably do so with a different constellation of people. So you'll be signing a new agreement anyway.
Yeah.
So I don't think it's really an issue.
Right.
But
okay.
I'm obviously happy to be wrong about that. Written terms, all students and all tenants must get written terms for their tenancy. And there is likely to be regulations about what those might look like. Second reading, Michael Gove made clear he was going to impose regulations to set out what antisocial behaviour looked like. So it's starting to look a bit like Wales. And one thing that people have said to me, what happens if Labour was to implement this? I think you would find that the Conservative Party's regulations to what might be in a tenancy might be quite short. I suspect you'll find that a Labour Party set of regulations to what might be in a tenancy will be quite detailed and long, and will start to look quite Wales-like. Right. So there are differences that might simply appear in regulations, and this is one of the areas in which they might. Moving on again, as we're running out, as I'm already over time, so I apologise. You have to join a landlord redress scheme. You must join it before you can market your property. So any new landlord entering the sector is going to have to join a redress scheme. No one knows how many schemes there's going to be. No one knows the fees. All I can tell you is that if you don't join, you'll be liable for prosecution or civil penalties. And in theory, you can be ridden out of the sector because you can be expelled from a scheme after an appropriate process, in which case, of course, you won't really be able to be a landlord because you have to join a scheme to actually rent your property. So it's actually a mechanism of removing landlords from the sector as well. There is an interesting problem at the moment in that the Court of Appeal has suggested that if ADR is available to people, then it has to be used or can be forced to be used before going to court. And so one of the interesting side effects of all of this is that it may be the case that landlords are able to turn around and force tenants to use redress schemes to deal with tenant complaints rather than letting them go to court. But relatively few student tenants go to court, so I'm not sure whether it will be that big a deal. So moving on again, property portal. Everyone will have to register the property portal. It is basically a national landlord registration scheme. Again, you're going to have to do it before you can market your property because you will actually have to put your property numbers, your identifier numbers, into advertising. Obviously, there's a danger for landlords who buy properties that they then need to get onto the portal if it's not being processed quickly enough that they miss marketing windows, which are often relatively tight for the student sector. So that is a potential concern. There will also be a fee, and no one knows how much it's going to be, although I should point out that you could actually give bits of it to local authorities. Again, although this provision's in there, Conservative people I've spoken to say, oh no, we would never do that. I'm not sure that a Labour government would take the same view. So another possibility where you see a difference between different parties is I could see a Labour government giving part of a PRS database fee to local authorities to help fund enforcement activity, whereas a Conservative government probably wouldn't. So there's subtle differences there again.
Do you think that there's any chance that the property portal see the end of some of the multiple licensing schemes that you've got around the UK? Selective licensing, additional licensing, that sort of thing?
Not immediately. I could see it actually leading to them being smaller. So it could see the end of the big blanket schemes that you see in Oxford or Newham or places like that, or
Nottingham as well. Yeah.
But I think that you'll still see some schemes in hotspot areas, and some of those are likely to be student areas.
Okay.
Moving on. I've mentioned Wraxall and Jepson. So at the moment, if a landlord is renting a property lawfully, but it's sublet without his knowledge as an unlicensed HMO, then the tenants are able to seek a rent repayment order against their landlords. There was some attempt in Wraxall and Jepson to go after the superior landlord because the intermediate landlord was just was a company with no assets. And the Supreme Court said you couldn't do that. You could only go after your immediate landlord. The Renters Reform Bill is changing that and basically allowing people to go directly after superior landlords for recovery of rent. So I mean, there are potential problems in the student sector with unlawful subletting. There are people, for example, who rent properties as family properties, and then they are taken and unlawfully sublet into the student sector. That potentially will affect in that context. But landlords who are caught out are in a much more dangerous position. Nearly there.
Right.
As I've indicated, there was a huge group of amendments going down on this bill. I've talked about a couple of them. The strongest one by far is forcing tenants not or not allowing tenants to give notice in the first 4 months. That's likely to be accepted by the government. But there are also amendments to get rid of all selective licensing. So what you just asked about, Irving. Keeping Raxon and Jepson intact, and also not requiring landlords who already have a letting agent to join a redress scheme, so you don't have two schemes basically operating, because agents already have to join redress schemes. It's not clear what will happen. Those amendments have got quite a lot of people signed up to them, quite a lot of MPs, so they are powerful, and the government's going to have to do something about it, which sort of brings me to my next slide. Because there's no date for third reading in Commons. It was meant to be the end of January. It keeps disappearing. It might be mid-February. And then, of course, you've still got to hit the House of Lords. And there is now some debate about how serious the government is about this. The government doesn't want to have another rebellion. You can't operate a government if your MPs are constantly rebelling against you, especially not as you come up to an election. So the government is stalling the third reading. Now, it may be stalling the third reading to get a deal together and to move all this forward productively. There is a suggestion they're trying to let it die quietly. Now, a lot of this has to do with your election date and your bill priorities, because, of course, the government wants to get its Rwanda bill through. That takes time. The government has now announced 2 days ago, formally, a bill to ban vapes and disposable vapes. It was in the news yesterday. And also, of course, to stop kids, effectively stop kids under 18 from ever smoking a cigarette, ever. That requires a bill. That's got to get through. As of last night, the government, as part of the deal on power sharing in Northern Ireland, has now committed itself to writing another urgent bill to do various things with Northern Ireland, and it's got to push that through as well. And you can't do all of this stuff.
No.
So there is an issue as to whether the Renters Reform Bill might just die. There are quite strong groups of more right-wing Conservative MPs who take the view that if you pass this bill, you irritate about 2 million landlords who will probably vote Conservative, but if you irritate them, will probably go and vote Reform UK.
Yeah.
And therefore, there's Conservative MPs who are nervous that they're going to lose their majorities to Reform UK, who's committed to standing against them and have the Labour or Lib Dems come through the middle and take their seat. But in practice, I think, ironically, if I was a landlord, I'd rather have this bill. Well, I am a landlord. If I don't, my wife's a landlord. I'd rather have this bill now than have it under a Labour government. There's an argument for saying, well, you know, if it's beaten today and it goes away, then it's gone. But if you take the view that Labour's more likely than not to win an election, a Labour version of this bill is likely to be more challenging for the private rented sector to deal with.
Yeah, so it might be a worst case scenario is the potential, and as you say, what Angela Rayner has already said about what they're going to do within the first 100 days. So,
well, she's got a busy 100 days ahead of her, that's for sure.
She has. Right. Okay. So I think we are there, aren't we? That's the final slide.
If there are questions I haven't answered, I'm happy to try and answer them.
Let's try and whiz through these. Let's have a look. Where can we start with? So at the very top, we have got, try and do as many of these as possible. Patrick Billick says, David, can we use company lets as used before 1988?
Yeah, if you can get students to create companies, but I'm not sure how easy that'll be.
Robin Walsh, this is the second one from Robin. This is quite a handy one as well. There's a two-part HEPI blog published yesterday and this morning picking holes in the new amendments to create a mandatory ground and that all tenancies have to be joint contracts. Is the government making things up as they go? and what's your view on the possible unforeseen consequences of the current proposal of the bill? So just for
I haven't read the blog, so
yeah, okay. So it's on HEPI, which is Higher Education Policy Institute. I've seen it. I've not actually read it yet. It's by I think it's by Martin Blake. He was the until very recently the chief exec of Unipol. He's recently retired. So yeah, it's worthwhile having a look at that. I'm not too sure what yeah. So you haven't read it, so it's hard to say. Okay.
I'm sure he has a series of perfectly reasonable points.
Yeah.
I mean, what do I think the government will listen? I don't think it's as simple as that.
Mandy Mills has said, do you think Labour might be more sensible the student market, though? I think the answer to that is you've said quite comprehensively no. Would that be fair to say?
Well, but the problem is your view of sensible is not the same. The reality is the reason that this is written the way it is because it is an NUS policy position and always has been a very fixed policy position that that students shouldn't get a worse deal than anyone else in the sector.
Yeah.
So the reality is the reason that there is no, or up until recently, there's been no special arrangement for the student sector is because it's NUS's firm policy position. Now, ironically, there are quite a lot of local student groups who don't agree with NUS on this, and I've had some quite fierce arguments with them about it. But I don't need to point out to you that NUS has a relatively low currency in the Conservative Party and a much higher currency in the Labour Party.
Yeah.
So no, I don't think that from your definition of sensible, no, I don't think the Labour government will be more sensible. But I don't think they see it. I think you're not really using sensible in the right tense. The way they would see what they're doing, see it as eminently sensible. But for
it depends on the context.
It's a perspective problem.
Yeah. Okay. Elliot said, will the possible amendment also apply to international students who are coming to study for a semester and don't require accommodation for longer than 5 to 6 months?
No. I mean, the only amendment that's been put forward is simply that students can't give notice inside the first 4 months. But that's not to say that people couldn't agree with students that there would be departure. I wouldn't say the amendment's perfect and resolves all problems. It resolves a specific set of problems.
Okay. Jeff has said, what about students who won't leave at the end of the term year? Well, presumably
we'll have to give them notice and go to court. That's precisely the problem.
Ground 4A, that is, yeah.
Yeah.
Pollyanne has said, Labour are surely more likely to prioritise house building and the reform of social affordable housing. It was stated in the session of the Labour are likely to go deeper and make more changes that people won't like. Are you able to substantiate that with any facts? The current government has made higher education a hostile environment.
Obviously, I can't substantiate it with facts because the Labour government aren't in power. They have said that that they would pass something like the Renters Reform Bill, but harder.
I mean, you've got the evidence of what they've done in Wales as well, haven't you? Right?
Yeah, and you can look at what they've done in Wales, but it's a subset of the Labour Party. And you can look at the amendments they've set down to the Renters Reform Bill, which are much more substantial and far-reaching, none of which have been accepted.
Yeah. This is a good one from Helen. Helen said, do you think the government is looking to encourage PBSAs and less use of PRS to adjust the sector? That's hard to know.
Well, I mean, the government certainly has had a long-term view that it doesn't think that amateur landlords should be in the rental sector. And yeah, for sure. There's a lot of money being given to the government by the housing sector at the moment, and it's not being given by small landlords, let's put it that way.
Okay. Apologies that we're having to whiz through these, but we are sort of running out of time. So, Pollyann, student possession, is that a mandatory HMO or would that be covered by selective licensing?
It's neither. It's an HMO as defined by the Housing Act 2004, some of which need licensing, some of which don't.
Right. Okay. So it's a HMO is basically what it is. It's not relevant to whether or not it's selective, additional, mandatory, or what have you. It's just the fact it is a HMO under the act that you just said, yeah?
Yeah.
Helen Robinson, the problem with 2 months notice is the ability to advertise the net for the following year. Will this shift viewings on the notice period, which will likely coincide with peak exam periods?
Yeah, I mean, one of the things that I've said to students is that you're asking to ministers and to MPs, you're asking students to go and do viewings on during exam periods, and that's it's just madness. They've got better things to do with their time.
Sure. Helen said, and this is exactly what you said, the point that somebody would make. Helen said, if I provide cleaning and gardening, would this get around the bill? I mean, you're just going to need far more technical advice than that, really.
Yeah, I mean, the answer is maybe, but it depends. And I see Ruth's asked a similar question, 2 down. Here I saw authorised officers such as cleaning. Would that take out the agent? What sort of a notice? Well, the answer is they wouldn't have to give notice, because it would be a fixed term tenancy.
Yeah. So if that's the sort of angle that you want to go down, you're going to have to go and take some specific legal advice, aren't you? This isn't the sort of thing that you should or try to do by crossing out tenancy on the top of your current document and altering it in some way. It won't work. How did Scotland do it?
No idea. I'm not a Scottish lawyer. Right. Sorry.
Okay. Sorry, Mandy. Would we be able to receive the recording session, because this is very interesting discussion? Yes, Kay. So the answer to that is it will be on our YouTube channel. So we will send you a link out to it as well, I believe, at the end of this. But it will definitely be on our YouTube channel, so you can look at this to your heart's content. Presumably, from what's been said, even if one student leaves, there would have to be a minimum of 6 months.
Well, yeah, I mean, if I see what's been said, if the amendment I've talked about goes in, then yes, if one student gave notice, there would be a 6-month minimum period before they could do so. Yeah, that's true.
Okay. Again, the same person, Pollyanna, said there are very few non-premium PBSA who offer in-room services locally. I can only think of one that does it. I mean, I can think of one national chain that offers cleaning and so on.
I will admit that I work and live around London, and quite a lot of London ones do.
Right. Okay.
But I completely accept that the student sector is not homogenous.
Grant says, I would have thought using your student house as an Airbnb would be a breach of their mortgage.
And because no landlord would ever breach their mortgage. I'm sure it would be.
Yeah. Hope that answers that for you, Grant. Lillian, what happens to council tax liability if there is a license granted to students?
It doesn't really matter. But council tax exemptions for students apply if the property is fully occupied by students in full-time education. It doesn't matter the term of the occupation.
I'll do a couple of these quick ones. Mandy Mills, I don't think Unipol is countrywide. Is it? Please clarify. Okay, so yeah, so Unipol. I mean, I don't work for Unipol, and I shouldn't be speaking for them. But I know them very well, so I can say Unipol operates in 3 locations. They're certainly national from the perspective that they run the ANAC code, and that applies everywhere. So yes, they haven't got an office in every city. That's certain, but they are a fairly significant organisation. I hope that answers that. Kay, I pay to ICO.
I've dealt with that. That's something totally different. Don't worry about it.
Okay. Pollyanna, is there any detail on how enforcement will work? Local councils already massively overstretched. I definitely agree with that.
Mostly by luck, I think, is the answer.
Yeah.
The government hasn't promised any new money, but it's too early to say.
Ashley, quick question. Sorry if this has been answered already. With respect to student accommodation sublet to students via landlords through agents, as they are not purpose-built student accommodation, how would fixed-term contracts work and the removal of Section 21?
You'd have to use Round 4A under Section 8, yeah, as you anticipate.
Okay. And then the last couple. How do you see the impact of the bill on student-facing lettings agencies? Well, I'll answer that, I think, Andy, because I am a student-facing lettings agency. I mean, I think the answer to that is, I'm assuming you are too, I think the answer is going to be pretty difficult. It's going to be the answer. The biggest issue, as far as I see it, is landlords possibly thinking, actually, do you know what, this is just too hard for me to do. I'm just not going to do it. So that's the worry. And I suppose the people where you've got small numbers, that, you know, maybe they've got one house or something like that, they just think, actually, I'll try and rent it out to somebody else, or maybe we'll go to a family or something like that. So I feel your pain is the statement I'd say, Andy. So not easy, I don't think. One left from Vishal, if you can answer that, David, and then we'll wrap it up.
What does it say about tenants? It doesn't say anything. That is up to you to address in your tenancy agreement. Obviously, if students are permitted to sublet and they sublet to non-students, you won't be relying on ground 4A very easily.
Okay. And with that, I think we are there. So if we can, yeah.
Apologies for overrunning. I hope it was useful.
Yeah, so a quick run through. If we can go back one slide, Dave. So yeah, if you anybody wants to contact David, there's his contact details. Please do so. Little me, I'm at the bottom there. I oversee Sulets. We will be doing a third one of these if and when this goes through Parliament, where we'll actually look at what the bill says and hopefully give you some actual concrete information then when it becomes law. And we'll be doing a 6-month. We're going to start doing 6-monthly legal updates. If you've joined today, thank you very much. We'll send you the details through those, and we'll send you the details where to find this webinar. So thanks for joining us. Thanks to David. Speak to you again soon.